Poštovani predsjedniče
Dear
Vujanović,
President Vujanović, I wish to welcome you, to greet you especially because you are a real lawyer among us, and you have shown it by staying here and listening to our presentations. All of you, I greet, dear all. I'm here because it is for your own benefit, because when I sit, I speak for about 45 minutes or 1 hour. When I stand, it's a bit shorter. So, to start with the topic, this topic that is ahead of us in the next 2 days and contains the title, The Role of International Law in the Promotion of Human Rights, is very wide. And that is shown by the position of practitioners, scientists, politicians that are speaking at this conference. The topic can be discussed from the position of different institutions and 2 frameworks at least. These frameworks contain the possibilities for the strengthening and promotion of human rights. One of these frameworks is the normative one, and the other is the institutional one. I first want to start with the possible definition on how to define the law on human rights. And you can agree with me that there is a series of definitions that can be a response to this question, and I will give you just one that is simple and understandable to me and goes to the essence of the things. It's a collection of rights that deals with the protection of individual freedoms, but also democracy. Starting from my institutional position, where I'm a judge of and president of the Supreme Court, it is clear that in the introductory part, I want to focus on the judiciary as one of the 3 branches of power and as a collection of institutions, because the judicial protection of democracy generally and human rights specifically within that is a characteristic of all democracies in development. I want to say that I'm not dividing democracies into old ones or developing democracies, but democracies that are developing towards protection of democracy and human rights, those who are stagnating, and unfortunately those who are doing this worse and worse. And we can find examples for all these things I mentioned. I start here from Europe and the experience that we have in Europe. The main component and the reason for the existence of the Council of Europe is preservation of individual freedoms and democracy. It is visible from Article 3 of the statute that defines that every member of the Council of Europe must accept the principles of the rule of law and enjoyment of human rights and fundamental freedoms of all persons within its jurisdiction. The standards and principles that they need to accept and implement are defined, therefore. The normative framework of the human rights of the Council of Europe is based on the Convention of the Protection of Human Rights and Fundamental Freedoms from 1950s that guarantees basic human civil rights, but there are also institutions, monitoring institutions. As for the Convention for the Protection of Human Rights and Fundamental Freedoms of the Council of Europe, we need to also mention the UN Declaration of Human Rights, because these 2 conventions have a respectable history. The convention has been acceded by states out of Europe, and rare jurists claim that this is a normative instrument that creates at least some principles that are binding for the system of human rights. In assessment of the significance of the role of international law in the improvement of human rights, I start from the position of a practitioner that turns abstract a legal norm into specific life situations. The principles established for the protection of rights and provisions that protect these rights can have value only if they are applied in practice and they achieve their purpose, and that is the protection of human rights. So legal norm can live only through practice, through court decisions, through specific cases, and without reducing the significance of the international legal instruments. I want to stress that the judiciary and judges specifically are creators of justice and law, and their understanding or interpretation of legal norms and the manner in which they implement these norms in specific cases is important in that aspect. As a judge, if I want to give a focus on something, I want to mention the sources that I mentioned, the Convention and the General Declaration. I want to also put forward the significance of international courts that apply these instruments, especially the European Court for Human Rights and the Court of the European Union, whose decisions become a part of case law, and they are a source of law up to an extent. Both courts are very important authorities in the interpretation of European law, independently from the fact that compared to the law of the European Court, the decision of the European Court for Human Rights are binding only for the state that participated in a specific case, but also for other state parties. The decisions of this court are important because of the conclusions stated in its judgments, which deal with the violation of human rights, if the same problem exists in their legal systems. So through their decisions, these courts give guidelines through balanced and autonomous interpretation of provisions that protect human rights. National courts must put additional efforts in finding a balanced application of the established legal standards in this area, so that they can meet the obligation and interpret the national law in accordance with the standards, which is the crucial element in the process of democratization and establishment of the rule of law. That is, from the point of view of courts and judges, a big challenge, but a burden at the same time. When I speak about the challenge, it is a big professional challenge, I dare say sometimes a political challenge, and we must be ready for that and immune to that. From the point of view of courts and judges, one of the important violated rights defined in the Convention, and I want to say something specifically, is related to the court proceedings. The Convention defines the right to fair trial, the right to effective legal remedy, presumption of innocence, and the right to defense, the principle of legality and proportionality of criminal acts, and the right nebis in idem, which means trial or punishment for the same criminal offense. And looking into the practice of the European Court of Human Rights, I find that an important part of the practice is protection from torture, which is defined in Article 3 of the Convention, and the right to freedom and security defined in Article 5. They are mostly violated in criminal proceedings. Criminal proceedings and court judgment try to ensure protection of individual society from criminal behavior of individuals. So these principles refer to human rights, referring to right to life, freedom or dignity. And that is why it is important to protect human rights in these areas. More and more crime gets international aspects, so it is necessary to have cooperation of different states in fighting it. And that is why it is important that in every state involved in fighting crime, human rights be effectively respected. It is a basis of mutual trust with of legal systems of different states, and cooperation, without which we cannot have effective fight against crime. Development of freedoms, security and justice is one of the goals of the EU. Efforts put in that are important for ensuring security of member states, but also establishment of mutual trust within the EU. But these are the values that are also universal and necessary in all societies and systems. In this way, judiciary gets a firm framework for fulfilling its obligations. The principle of mutual recognition has been promoted as a cornerstone of cooperation in 1999, the meeting of the European Council in Tampere, which was later built into the Maastricht Treaty in Chapter 5. Comparative case law of the European Court with the European Court of Human Rights can mean that sometimes we neglect the role of member states for protection of human rights, but protection and mutual recognition of judgments cannot compete with the protection of basic rights, because protection of basic rights is the main principle of mutual trust and recognition. Having in mind the member states are convinced that human rights are respected in the whole EU and on a wider scale, they can recognize court and out-of-court decisions from other states as their own. I also want to say something about the role of judges, but we'll leave it for the discussion later. I just want to conclude with the following statement. Without wishing to reduce the role and importance of international sources, I also want to draw a parallel with the saying, the road, the path to hell is paved by good intentions. So we cannot proclaim the principles of human rights if the protection of these rights is not ensured and implemented in practice, not only through the work of courts, but other state bodies, NGOs, which in their work deal with human rights. That is what the former member of the government from Germany also mentioned. Thank you for your attention. I wrap up with it. 45 minutes passes quickly, as you can see.